Welcome to the Block and Tackle Show, hosted by Karl Block. Karl is a partner in the law firm of Loeb Loeb here in Los Angeles, California. He will be tackling some of the biggest issues in business today. Listen, learn, and enjoy as he leaves no stone unturned during deep conversations with some of today's most amazing business leaders. Welcome to the show.
Hi, everyone. Welcome to the Block and Tackle Show. On today's episode, I am very pleased to have a distinguished guest and colleague, Frank D'Angelo. Frank is located on the East Coast. Obviously, you can see in the background, he has his sports teams that he roots for. We won't talk about which basketball university he went to for college, but after he graduated law school, he started out at Wall Street law firm in a wide variety of litigation practices. And he was kind enough to come to Loeb, and we were happy to have him. And today, while I know Frank with a very broad litigation background, including a lot of commercial litigation and actually securities defense work, today we're going to talk about something that has been occupying a lot of his time. And it's a very, very important topic. And for those of you who regularly watch the show, and you knew that I had Evangelos Samoudis on and Anatoly Kivnitsky on, and they talked about a lot of very, very contemporary things going on with AI and also risks. And one of the main risks is copyright protection. Well, today we decided to go to the source. And Frank has dealt with a number of AI issues, from a legal perspective. And that's what we're going to talk about today. I'm super excited to have Frank. Frank, thanks for agreeing to come on to the Block and Tackle Show.
Thanks, Karl. Happy to be here.
Well, that's good. So I think, based upon what you and I have talked about and understanding that there's going to be some lawyers who do watch this, but there's going to be a lot of business people who watch this who aren't going to be familiar with a lot of copyright law. But I think it's safe to say that as a basic matter, people probably know if you don't have a protectable interest in copyright, you can't sue to enforce a copyright. So in that regard, let's talk about where we are, the state of the law on what is protectable when you use AI to create some form of product.
Yeah, look, it's certainly something that's top of mind now. We're getting tons of questions from clients about it, and for those of your listeners or watchers who use AI tools, whether for work or personal reasons, to create art, to create material for their jobs, it's something that they've got to be concerned about as well. But we're still in the early days of AI, still in the early days of the Copyright Office and courts sorting out how we're going to be judging the protectability of AI generated content. Still in the early days of a lot of litigation against AI developers, the developer of major AI platforms and tools, and I'm sure things are going to change as we go on. But it's an exciting time to be practicing in the area, and we could have the same conversation 6 months, 12 months from now, and I'm sure the state of the law will be entirely different then. We'll have a lot more information then. But at this point, at least, it's an exciting time to be talking about it.
It's interesting because this is one area, and there's others where Congress or others write laws many, many, many years ago without anybody ever contemplating that there could be something like AI, and that you could have a generative tool that could literally create content. When would anybody ever have thought about that? And so, but now we're here, and now courts are put in difficult situations without really much statutory guidance, right? And then,
yeah, I mean, look, what we know is that dating back to the 1909 Copyright Act, that there needs to be some kind of human authorship in order for a work to be protectable, and that sort of linchpin of what is protectable and what is copyrightable, that human authorship requirement has been a constant over time, right? And there was a popular case a number of years ago that PETA filed on behalf of a monkey that took a selfie of itself using a wildlife photographer's camera. And the courts held that it's not protectable, can't be copyrighted because it's a monkey that took the photograph, not a human, right? So we've had instances like this crop up over time where this human authorship requirement has been tested, and time again, courts and other authorities have held that you have to have a human creating the work. Of course, it's still a complicated question because there is some human involvement in the creation of this AI generated content. And we're talking about generative AI. Chat GPT, Midjourney, Stable Diffusion, those types of tools. There is still some human involvement. So the question is where you draw the line. Just because you have a human on one end inputting, instructions, prompts, helping to generate the output, to what extent is that going to yield a product, a material that is still going to be copyrightable?
So in that regard, when you talk about the human, which makes sense as we're talking about it, but a big part of this is how much human involvement there is, right? I mean, and I know you want to talk about that. And in theory, humans created AI platforms to some degree. So how much, obviously, if a human just created the platform and then everything that came from the product was copyrightable, then that would be that. Basically, the first person to put the query in or the command in could run to the copyright office. So common sense, I think, would tell business people you can't do that. But then as you go along, it gets more nuanced. So where do you see the state of the law now, such as it is? And, how do you think this is all going to play out?
Yeah. So, I mean, we're talking right now about protectability. If a user is using the platform, the output that's generated from the AI tool, to what extent is that copyrightable, right? There's a whole other set of questions surrounding potential liability for the developers of these tools, right? And I'm sure we'll get to that eventually. But as far as the protectability of the AI generated output that sort of originates with some kind of user prompt, what we're seeing by and large, it still is being determined on a case by case basis, but by and large, the AI generated content tends not to be protectable. And the reason for that is, let's start with sort of a simple example, right? You sort of say you're using an AI image generating tool, Midjourney, for example, and let's say the prompt you're inputting is, draw me a picture of two lawyers talking on a podcast, generate an image like that. That's a pretty simple prompt, and it's going to spit out an image, right? The image it's going to spit out is it's going to be within the discretion, effectively, of that AI tool what that image is going to look like. A simple prompt like that, you have no control over ultimately what the appearance of that image is going to be.
Sure. Although,
how,
don't you think
how the lawyers are going to look, or what's in the background, or what colors are going to be used, the composition of the work, right? It's going to be up to that tool to make those kinds of decisions, right? And because the human that's inputting that instruction, inputting that prompt, is not sort of controlling all those elements of that creative output, something like that clearly is not going to be protectable.
I was just going to say, I think that some of the business people who just heard that example, they think, of course, there's all going to be pictures of Darth Vader if it's two lawyers talking about anything. But your point is well taken. And then, so just with the author, creator, really not doing much by putting a prompt in, okay, probably not copyrightable. But what about how much more effort does the creator have to do, where you see the potential that you could go to the copyright office, protect it, and of course, enforce?
Yeah, it's a good question, and unfortunately, there's no easy answer to it now. We have a couple of good examples over the past, year or two of sort of test cases that maybe help us predict where the line might be drawn. But we've seen instances where, again, using the example of an AI image generating tool, where you can have a user type in over 600 text prompts to generate an image, and it's still not protectable, right?
Wow.
Because again, that AI tool is still gonna retain some kind of discretion. It's still gonna make the decisions regarding how, based upon the data it's been trained on. Still gonna make the decisions regarding what that ultimate image is gonna look like. And as a user, typically you're not going to control, or sometimes not even going to have the ability to control the placement of each element of that creative output, right? But again, there are artists. Some would call them sort of activist artists that are sort of testing the boundaries here and testing the limits of these principles, right? There's one AI artist that recently submitted an application to the Copyright Office where she created a hand drawing of, it was a cyborg with roses coming out of the cyborg's head, right? And she claimed that she used this AI tool, Stable Diffusion, to control exactly what the output would look like, right? So that she conceived in her mind what she wanted the output to look like, and she used as a seed this hand drawing. She instructed the tool to use her hand drawing of the cyborg as a starting point, and then she used certain tools within the platform to control, how that hand drawing would translate into an AI generated image. So she claims she was able to control, the sort of hyper realistic appearance, the photorealism of that output, the sort of AI version of her hand drawing. And she was able to control the appearance of the depth of the cyborg's face. She was able to control the types of flowers, roses, the colors of the roses. She was able to control the lighting. All those elements, all those creative elements. She and her attorneys claim that because of the precise prompts that she was inputting and because of the precise tools she was using, that she was able to dictate exactly what that image looked like, and that someone else using the same prompts and the same tools that she used would generate the exact same output, right? So we haven't seen a decision on that application yet, but it's those kinds of applications that I think are sort of testing the boundaries here. And we may get to a point where, because I think the Copyright Office and courts are looking at this on a case-by-case basis, we may see an instance where you have an artist or an author that is really exercising a higher degree of control over the output, or maybe we might see something that ends up being protectable. Right now, we haven't really seen it.
I understand. So there's two things that come to mind when you say that. So first, let's say that somebody put those prompts in to get an image, and then AI generated the image. And from that image, somebody moved things around or altered the shape a little bit or used different colors or added things to it. And, text, anything else. Would that be what happens at the Copyright Office when that happens?
Yeah, no, it's a great question. Where you've got that human involvement after the fact,
Mm-hmm.
even sort of tinkering with the output, adding some new material to the output, those human created elements are going to be protectable. But the elements that are solely originating with the AI tool are not going to be protectable. So I'll give an example. The same artist that I made reference to earlier, who submitted this, an application centered around this image of a cyborg. They had earlier created a comic book, basically using images that had been generated by an AI tool. I think it was Midjourney in that case. So the images used for the comic book were generated by an AI tool, but the text that was overlaid over the images, or the comic book text, that was authored by a human. What a human also did is a human took the artist in this case took the AI images and arranged them in a particular manner, sort of selected what images they would use, arranged them on the pages in a particular way, put them in the order in which they wanted those images to appear. And the Copyright Office held that the selection of the images and the arrangement of the images, that was protectable because there were creative elements to the selection and arrangement of the images, and obviously creative elements to the human authored text. So those portions of the final work are subject to protection. But the original images that were generated by the AI tool, those are not subject to protection, right? So Karl, I don't think you're a comic book artist. It's never come up in our conversations. But let's say you wanted to make your own comic book using the same images that artist had used for their comic book. You would just have to change the text, and you would have to change the order and the arrangement of those images. Those images in and of themselves aren't protectable, not subject to copyright protection.
Understood. And the other thing that's interesting about this is, start from the proposition that code is copyrightable. When people create software programs, code is copyrightable, right?
Yeah, sure.
Okay. So are the queries, the commands that you put into AI to generate those images like you're talking about with those artists, would those be copyrightable?
They could be. They could be if they're sufficiently creative. That's There hasn't been a lot of law surrounding that issue, but there's been some scholarship, some writing on it. Again, it's gonna depend upon the extent to which the prompts are sufficiently creative to be subject to copyright protection,
And
right?
that's intuitively makes sense, just like writing a book. But from a business perspective, this is going to be up to the Copyright Office and the courts, right? I mean, there's no clear guidance about any of this, really, is there?
Well, there is guidance that's been issued by the Copyright Office. Because they're seeing thousands and thousands of applications now,
Hmm.
for AI generated content. And so there's some guidance, specifically regarding, how to fill out your application, what information you have to include,
Sure.
how you have to disclose the involvement of an AI tool as a co-author or part of the creation of the work. And there's some guidance in terms of what the office is going to be looking out for, but it is still being determined on a case by case basis.
And without giving away trade secrets, and we're not giving legal advice here, but it must be hard when people come to you, and often people come to lawyers to try to get some level of certainty, and it must not be easy.
I don't have to tell you, Karl. Part of our job is thinking of creative ways to say it depends, right?
I get it. I get it. So, okay, and I think this will give our viewers and our listeners a pretty good idea about, in the creative works, how that sort of thing works. And I just want to touch on sort of the business aspect of it. If somebody uses code to create a business software, and that generates a unique thing that somebody wants to copyright, are we looking at the same principles there?
Yeah, I mean, again, I know we've been talking about, artistic works and visual art and other kinds of art forms, but I mean, the same principles are going to apply, right? And this is where you really get into questions of what kind of input is being used, right? So, in the sort of normal case, or the sort of, more unsophisticated user case where it's not an enterprise user, it's not a business that's using a tool, you're operating solely on the tool that's been trained on pre-existing data, the data that the developer has chosen to train that tool on, right? Enterprise users sometimes have the ability to tweak the data set. You can feed in, your own input, and we've seen, even from a litigation standpoint, we've seen, for example, discovery tools where you have document review platforms that are powered by AI, and you can train that document review platform only on documents that have been produced in discovery. You can ask it, you can ask it questions and have it generate answers based upon, a much narrower data set. So these questions become a little bit more complicated where you have entities that are actually tweaking the data set, because that's gonna generate a more sort of targeted output at the end of the day.
But at the end of the day, if there's a particular format for a business report or some other tool that is used in business, if it was generated from code done by AI, are the courts lost? Or I shouldn't say lost, but is it very unclear how they determine whether that product would be copyrightable or not?
Yeah, I mean, look, if it's going to depend upon the extent to which the user, whether it's an enterprise user or a non-enterprise user, is sort of controlling the output, right? How much control are you able to exert through the input? I mean, talk about a totally closed system where you're just training a tool on data that you have, data that you own, right? So let's say you have, a host of forms. Let's say, Karl, you were to use or develop an AI tool. You trained it, exclusively on, business forms that you've come up with, or transcripts that you've generated. Because you already own the rights to those materials. Presumably, you've authored them yourself. Maybe you might have even filed an application with the Copyright Office. There's no issue there, obviously, because the tool is being trained on data that you already own. is generating output that has a very, very low risk or no risk of being infringing. And it certainly is much more likely to be protectable in that instance. But where you're using a tool that's been trained on data that you don't have control over, then it's then you're in a situation that's a lot less clear.
Okay, and intentionally or otherwise, that was a great segue to the next topic we want to talk about, which is what if when you're using content, you cause or you use copyrighted materials, whether you're either training the AI or the AI generates it. How does that work?
Yeah, I mean, look, this is we've gotten questions from clients on this quite a bit. I've had more than one client come to me and say, look, I want to generate some marketing asset. I want to generate some image or text I'm going to use for marketing and promotional purposes, but I don't want to pay to license something. Can I have an AI tool generate this image by creating whatever prompts I think, inputting whatever prompts I think are gonna get me the type of image or the type of text that I need. You can certainly do that, but there are risks and limitations to it. I mean, sort of principally, as we discussed a moment ago, that output is almost certainly not going to be subject to copyright protection. But secondly, there is a risk of inadvertent infringement there, right? Because these tools, there's very little visibility into the pre-existing copyrighted works that these tools have been trained on, right? So you can have an output that, unbeknownst to you, might be substantially similar to some copyrighted work that tool had been trained on. And you might not know that because you have no visibility into the training set, right? And unless you're performing a clearance search or sort of doing a substantial amount of diligence surrounding that output to see, is there some pre-existing work out there that is similar to what's been generated by this tool? You might be using something that might be infringing, and that's a risk that I think clients might not be aware of, and it's something important to keep in mind.
And what if somebody uses AI to generate code, and then you have some sort of program that is run from that? And wouldn't the same thing be true if you're relying on something? The code is actually copyrighted by somebody else, you could have a massive infringement, right?
Yeah, look, there's a great deal of uncertainty surrounding this issue because, I think last I read this, there's 20, 30,000 at least businesses that are using tools, AI tools in order to generate computer code or portions of code, right? And so, that is. That is something that it's out there as an area of risk that might need to be addressed at some point. And it could be that there's code portions of which are not subject to protection. There could be entire sets of code that aren't protectable. And we haven't seen this tested through any court cases yet, but I imagine that we will in the coming years.
And you raised a good point that when we first talked about this, that I think when it comes to things like this, it's important to keep in mind. You had mentioned that the beauty of actually registering a copyright that's valid, of course, is that if somebody infringes, you can get something called statutory damages, which I probably want you to explain to our listeners and our viewers. As opposed to, let's say somebody generates some code to create a website, but doesn't make very much money off of that website. What are the damages? But if there's this thing floating out there like statutory damages, that's potentially scary. So why don't you take a sec and talk about that?
Yeah. So basically, the Copyright Act allows you to claim actual damages. So any damages that you've sustained and that you can demonstrate you've sustained by virtue of someone using your copyrighted work, or in the alternative, statutory damages. Mm-hmm. What that means is that the Act basically sets a range and says, for the infringement of any given work, the copyright owner is entitled, as an alternative to actual damages that they've sustained, statutory damages in the range of $750 to $30,000 per work infringed. Or if you can demonstrate that the infringement was willful you can get damages up to $150,000 per work that's been infringed, right? And it's a useful tool because sometimes you can't demonstrate suffering actual damages, or sometimes it's difficult to show I've been damaged in this particular amount as a result of the infringement, right? But you only have access to statutory damages by and large if you've registered your work prior to the infringement, right? So it's an incentive for creators to register their work. But if you've got work that has, at least in part, been created by an AI tool, you're required to disclose the involvement and is required to disclose the elements that have been created by that AI tool in your application to the Copyright Office, right? And if there's any confusion over what's been created or authored by a human versus an AI tool, the Copyright Office is almost certainly going to ask for more information, and you're going to be going back and forth with the office justifying what you've authored versus what the AI tool has authored. But no, statutory damages are absolutely a critical tool for copyright owners, and it's something that appears right there in the text of the Copyright Act.
Yeah. So the thing that comes to mind, and I think we know that there, for example, are people who traffic in patents and run around and acquire patents and then sue people for infringement. And now, if it comes to creating code, for example, if somebody has actually been able to acquire code that's been copyrighted, and the person who's using the AI tool doesn't know that the AI has that code, you could get the same kind of stuff, couldn't you?
Well, I mean, look, if you're acquiring, if the creator of the code is going to assign the copyright to you, and you're somehow acquiring an ownership interest in this code, most likely that code would have been registered with the Copyright Office, because you're going to want to have that measure of sort of validity and verification that it's subject to protection, right? And the only way that you're going to have a copyright registration in that work is if you've made the Copyright Office aware of what you've created versus what an AI tool has created, right? So hopefully those issues will be sorted out well before, in this hypothetical, an individual or a business would have acquired, ownership interest in a particular code.
And again, I'm more focused on the inadvertence and whether it creates mischief. And what I wonder is, how does this get solved? Because it sounds like with courts, I mean, judges and juries are very good at ruling, but there's many courts in the United States, there's many courts in the world, and that could be a very lengthy process with different courts coming out different ways on these sorts of things. Do you think there'll be another, international copyright convention, or do you think that there will be more U.S. legislation to deal with this? I mean, if you had to read tea leaves, and I recognize that's where it is, how do you think all that comes out?
Well, I think, look, I mean, there certainly is. There's been some, AI-related legislation proposed in the U.S. and at the state level. Nothing near what we're seeing, abroad. The most sweeping AI regulation that we've seen so far has been the EU AI Act. But I think actually when we're thinking about, the risk of potentially infringing AI output poses, I think it's something that the platforms are going to have to deal with as a way of getting users more comfortable with the risks associated with using those platforms, or as a way of mitigating the risks associated with using those platforms. And one thing that AI developers have done is offered indemnification, or various forms of indemnification to users as ways of getting them comfortable with using the platforms. And I think it's been an effective PR tool to say, look, we trust our tools. We think they're effective. We think there's a public good associated with them, and we think that the risks to users are relatively low. But if there is a risk, we're going to indemnify you. That's been the message that's been sent by the developers of these tools. Unfortunately, when you look at the fine print, the scope of indemnification is actually quite limited. Typically, they're only offering indemnification for enterprise and paying users, sometimes not even for low-fee models. There tends to be carve-outs where the input is infringing. There tends to be carve-outs where you're altering the AI-generated content after it's been generated. those are situations where typically these platforms are not going to offer indemnification. And most of these platforms are also not offering indemnification where the user knew or should have known that the output was infringing. So, Karl, what do you think that means? How do you think one can show that a user knew or should have known that the
Well, I mean, look, and obviously, if you break them down, knew, that might be easier to know and prove. The should have known, that's vast.
Yeah.
And I mean, I could even imagine, and this is your area, even, it may not be so seamless to do copyright searches either. So that how you must, from a litigation perspective, you must get into all of these fact intensive issues if you're going with the should have known. And then, you're going to have several litigations. You're going to have the litigation brought by the person who holds the copyright, who's suing for infringement. Then you're going to have litigation between the AI tool licensor and the licensee over whether the licensee should have known. And Frank's going to make a lot of money, but there's it just seems like there's not a lot of certainty, and that's unfortunate. And I understand the logic behind some of the content. I mean, some of the carve outs, because if you knowingly change something, that's understandable. And if you put in your own content that was infringing, that shouldn't be an issue for the licensor of the AI tool. But then, the other aspect of this, and I mean, the gentle people and people of goodwill don't necessarily talk about this, but what if the liability is so high that the indemnity is functionally worthless because the resources of the AI tool maker aren't high? And then I guess I would say to you, where's the insurance industry on this sort of thing?
It's a great question. I mean, I think that's where a lot of this gets resolved is, the extent to which there can be effective insurance products developed to cover instances like this. But look, I mean, we've seen OpenAI, Microsoft, Getty offer indemnification. There's a number of other developers that have offered indemnity, and these are well-heeled companies.
Sure.
So, they by and large can afford to indemnify, subject to the carve-outs we discussed. But yeah, I think seeing insurance products developed surrounding these issues and offered surrounding these issues is going to be important as well. We haven't seen a whole lot of litigation in this area. Really, the primary area in which we've seen AI-related litigation is lawsuits by creators against the developers of these major platforms.
Sure. But again, it could be coming, and I mean, not that what I'm going to say is a rule that applies everywhere. When you have existing tech companies and somebody has an inadvertent infringement for which they make no money and didn't even know, those companies may not be incented to go guns blazing against that inadvertent infringer. If you have people who acquire copyrighted materials and the copyrights behind them, they might be more inclined, because again, we're seeing that in the patent area. And so I don't want to be putting ideas in anybody's minds about the next great business venture for people, but it's scary to me in terms of just not being able to put a box around what the risk is. And what you're saying is it's new, and this is you make an omelet, you have to break eggs, and that's where we are right now.
Look, it's the nature of the law that the law is always catching up to new technologies, right? It's not the other way around. I mean, it's been like this for decades, and it's unfortunate that oftentimes we can't provide more concrete guidance, but it's also an exciting time to practice and to be certainly on the business side, to be developing these tools and to be using these tools.
No, I that makes sense to me. Thanks for tuning in. If you want more info on the show, please visit blockandtackleshow.com, and you can also email me at Karl@blockandtackleshow.com. Thanks for tuning in.